Alright, guys, today we are going to break down a courtroom battle that starts with one huge question. Should a man asking for father's rights first prove he's actually the father? Right out of the gate, the judge notices the contradiction. The alleged father wants parenting rights, but at the same time wants DNA confirmation before moving forward. That instantly sets the tone for the entire hearing. You can already see the court trying to balance legal caution with the emotional reality of a child who may already recognize this man as dad.
This matter comes before the court at this time for hearing on some initial motions that have been filed in the case. The first was the motion for genetic testing filed on February 17th by Mr. Moody on behalf of his client. Mr. Andrews has countered with a motion to file answer out of time, motion for a temporary order, and a motion for drug testing. Addressing the paternity issue first, Mr. Moody, your motion for genetic testing, not a whole lot of explanation there, just a bare bones request. Why is that necessary here?
Judge, we think it's necessary because the minor child in this case, he was born in February of 2024. My client, he does believe that he's the father, but before we start getting court orders and everything proceeding down the road, we'd like to ensure that that is the case. He's been precluded from having his last face-to-face contact with the minor child in this case was in April of 2024. He's had repeated requests to have contact with the minor child, and those requests have always been denied. So he's trying to participate and do what he can. He's been denied up to this point, but before we make him legal father, we think we need to at least have a genetic test to confirm that so that then we can proceed with the requisite court orders that follow.
There's a certain inconsistency there, though, Mr. Moody. Wouldn't you recognize he files an action saying, I want to be declared this child's father, but I sure want genetic testing to confirm that before we go ahead with anything?
I do understand the inconsistency, Your Honor. I mean, and obviously, we have to follow the paternity action to ultimately get court orders so that he can have parenting time. And that's essentially what my client wants to occur.
Buckle up, guys, because this section gets very interesting. The mother's attorney admits there's no real doubt about paternity, and nobody else has stepped into the father role either. That changes the atmosphere completely. The judge practically says what everyone in the room is thinking. The DNA test may simply confirm what both sides already know. Still, the court allows testing because once legal fatherhood is officially established, major rights and responsibilities follow. This moment shows how family court values certainty before making long-term legal decisions.
Um,
How does the birth certificate on this child read?
he's presumptive father based on the birth certificate, Your Honor.
Okay. Mr. Andrews, what is your position regarding the motion for genetic testing?
Your Honor, my client has no doubt that the petitioner is the biological and natural father of the minor child, but she also doesn't have any objections to genetic testing to confirm that fact.
All right. And so there's no one else who's performed the duties and role of a father other than Mr. Berry during the life of this child?
I think, Your Honor, we would probably take more of the position that there hasn't been anyone who's performed the duties and role of father during the life of this child, but certainly no one other than Mr. Berry would even have a claim to have done so.
All right. And I trust, Mr. Moody, that your client is in position through you to arrange for this genetic testing and pay for it?
He is, Your Honor.
There appears to be no impediment legally or factually that would cause this court to deny this motion. Confirmation of what I think the parties already know seems that it may not be absolutely necessary, but if Mr. Berry wants that confirmation, the court's inclined to have him pay for it and have this genetic testing conducted. So, Mr. Moody, the court will grant your motion for genetic testing if you'll submit a separate order regarding that particular issue.
Thank you.
Obviously, implicit in that is that the mother will cooperate
Alright guys, now the hearing shifts from biology to parenting time, and this is where the tension really starts building. The judge questions why the father has had almost no access to the child despite being listed on the birth certificate. The mother's side raises concerns about stability and alleged substance use, asking for supervised visits only. What stands out here is how carefully the court weighs risk versus relationship. Nobody is accusing him of harming the child, but the court still wants to move cautiously while making sure the child doesn't grow up without a father connection.
Regarding any reasonable request that regarding her participation in such genetic testing by producing the child or giving her own sample, whatever it may be.
She will appear with the child wherever and whenever it's required of her for that testing.
How old is this child right now?
13 months, Your Honor.
Okay. All right, Mr. Andrews, I think your motions were filed very recently.
They were, Your Honor, and I would just say that procedurally they were not filed within the last 7 days. So if Mr. Moody and or the court objects those being taken up today, I would understand that and just ask if we could set a subsequent hearing date for them.
All right. Why shouldn't parenting time for him get started now? Well, I guess rather than parenting time, let's just call it visitation. He is named as on the birth certificate as the father. Your client says that there's no doubt in her mind that he's the father, yet he doesn't have any participation with the child at this point. And why is that, Mr. Andrews?
Your Honor, my client has concerns regarding Mr. Berry and his stability and his potential substance use that would be contrary to the best interest of the minor child to have unsupervised parenting time with him. So she is not, well, I would say that she's not opposed to parenting time. We had requested, we're requesting supervised parenting time to start out with, that if that goes well and, in conjunction with the request for drug testing, if the drug test.
Buckle up, because this section reveals the strategic chess match happening between both attorneys. The mother's lawyer argues that starting parenting time before DNA confirmation feels inconsistent, while also pushing for drug testing based on past concerns. At the same time, he admits the mother is not trying to permanently block the father from the child's life. That's a major distinction. The court is now balancing fear, accusations, and the child's emotional future all at once. You can tell both sides are carefully framing their arguments to appear focused on the child's best interests.
Is negative for any controlled substances, that it would then, we would expect that it would then increase past supervised. But starting out, we're requesting supervised every Tuesday from 10 o'clock a.m. until noon to be supervised by Casey Calloway, which is a third party known to both of the parties. I frankly, I'd written the motion and then I received the motion for genetic testing. And so I revised the motion before filing it to state upon confirmation of the genetic test results, simply because in my mind, it would be inconsistent if Mr. Berry is expressing doubt as to the paternity to start parenting time if he believed that there was any possibility that the child was not his biological child. It now sounds like maybe there isn't any doubt. He just wants the confirmation. But it's just always kind of been in my opinion, that if a party is expressing doubt as to paternity, then starting parenting time before that issue is resolved seems to be inconsistent with, what would be a logical progression. The idea being you don't want to start parenting time only for genetic testing to come back and say that's not the biological father. So that was the reason I revised my motion to indicate, that we were wanting to delay the commencement of the parenting time until after those genetic test results come back. Otherwise, my client is prepared to start that. They've been doing FaceTime contact. It's just that they haven't been able to reach an agreement on how to do in-person stuff where both of them were happy with what the other was offering. So we believe that's in the best interest of the child to start out with the supervised parenting time.
All right, guys. Here comes one of the most revealing moments of the hearing. The father's attorney pushes back against supervised visitation but also makes it clear his client desperately wants involvement in the child's life. Then comes the surprising Ross situation reference, basically warning about the emotional disaster if bonding starts and DNA later proves he isn't the father. The judge listens carefully but keeps steering the case back toward the child's needs. Even with all the legal arguments flying around, the court's focus stays locked on building stability for this 13-month-old child.
And again, we do believe that drug testing would be beneficial, but my client has firsthand knowledge that Mr. Berry has a history of using illegal controlled substances. She has seen some indications during some of the FaceTime conferences that lead her to believe that he may still be under the influence at times. And so she's asking, and she's willing to pay for that hair follicle test. And then we would just ask if he does come back as positive that she'd be allowed to receive a judgment for the reimbursement for those costs. But she'd be willing to pay for those costs. And then if her fears turn out to be unfounded regarding the substance use issue, and there hasn't been any issues with regard to the parenting time, my client knows that is not intended to be a long-term parenting plan, what she's proposing.
I'm curious, Mr. Andrews, why Tuesday?
I don't know that I asked it. Is there a reason Tuesday?
It's the only time I have transportation, like official transportation.
She knows that she has transportation, reliable transportation to ensure that the parenting time is uninterrupted on Tuesdays. So she chose Tuesday just because she knew that would be reliable. Frankly, if that doesn't work for Mr. Berry, and they have a day that works differently, I think that we could try to figure something else out.
Mr. Moody, your client's position on this visitation plan, I think it's been suggested here.
Your Honor, I think my client would love to have supervision. I'm not sorry, love to have parenting time. I don't think there's supervision necessary at this time. Even if so, their proposed supervisor, we would request that Keegan's mother be.
Buckle up, guys, because the judge now takes direct control of the courtroom. He starts questioning the father about criminal history and pending drug charges, clearly trying to separate rumor from evidence. When no recent drug issues appear, the judge shifts gears completely. He points out that both parents already treated this man as the father from day one by placing him on the birth certificate. That becomes a huge factor. Family court often focuses on established relationships, not just DNA, and the judge makes it clear that a father-child bond should begin now, not months later.
Be able to supervise that parenting time. She's ready, willing, able to do so. We don't think there would be any issues there. I guess my only concern, this is not Keegan, Judge. Keegan's 21 years old. He has no other minor children. My only concern for him as his lawyer would be if he starts exercising parenting time now and then the tests come back later that he's not the dad, that we've got walked into a Ross type situation.
Okay.
And I'm not even certain Keegan knows what that means, but he's wanting to do what he has. He wants to be dad. He wants to be involved in the minor child's life. This is probably more a judge coming from his lawyer than Keegan himself.
Excuse me. Okay. And the Tuesday morning time for his visitation?
That works out. That works out on Mr. Berry's schedule, Your Honor. And he can provide, he can transport, he can come pick up, drop off, he's got reliable transportation that he'd be able to make the exchanges. My understanding is they live approximately 45 minutes apart from each other. But he's willing to do that. His mother's willing to do. Does Tuesday work for you as well? They're able to work that schedule, at least on a temporary basis, understanding that obviously eventually we'll want more additional parenting time if the tests come back confirming.
Where does she live?
In Art City.
I live in Winfield.
Oh, she's in Winfield. I'm sorry, Your Honor.
Okay. And Keegan, where does he live?
Here, obviously. Are you in Winfield also? He's in Winfield also. Sorry, I always get those mixed up. They
Okay.
both reside in Winfield, Your Honor.
Oh, okay.
Actually, Your Honor, my client resides in Cedar Vale, not Winfield.
Well,
Alright, guys, this part feels less like a legal fight and more like a reality check from the bench. The judge openly tells the father that caring for a 13-month-old is serious work. Diapers, feeding, safety, naps, and non-stop supervision. Instead of attacking him, the court tries to build a support system around him by involving the grandmother during visits. That is a powerful moment because it shows the court isn't simply handing out rights. It's trying to create a safe environment where the father can actually learn how to parent responsibly.
I apologize. Mr. Berry and his mother both reside in Winfield.
Oh, okay. I'm sorry. I misunderstood who you're referring to. I apologize.
Okay. All right, Mr. Moody, I've got some questions, and I don't know if you need a private session with your client about these answers that I'm asking for. Has your client been convicted of a drug offense in the last 18 months?
He is not, Your Honor.
Does he have any pending drug-related charges?
He does not, Your Honor.
Okay. And he and his mother both live in Winfield.
That is correct, Judge.
All right. Right. The situation before the court is this. Apparently, when the birth certificate was done right after the birth of this child, both parents either specifically consented to or acquiesced in Mr. Berry being named as the father of this child. There appears to be no other father figure involved in this case. This court believes that it's in the best interest of this minor child to start establishing a father-child relationship now, because this relationship has already been recognized by both parties. This doesn't come out of left field somewhere. This is something that for 13 months, both parties have presumed has existed. The mother's reticence to allow parenting time, apparently, she doesn't trust him for some reason, and then perhaps she has some concerns over prior drug use. Mr. Berry, the only thing I can tell you is that your rights to this child and drug use are inconsistent with one another. If you want court-ordered time with a child, that has to be separated from drug use. Those two are inconsistent.
Buckle up, because the court now officially lays down the temporary visitation plan. 2 supervised hours every Tuesday may sound small, but legally this is a major breakthrough for the father. The judge also carefully handles transportation logistics and even discusses car seat safety before allowing exchanges. That detail matters because family court decisions often revolve around practical safety concerns, not dramatic accusations. Most importantly, the judge repeatedly emphasizes that a child benefits from knowing both sides of the family whenever it can happen safely and responsibly.
I'm not going to require any testing at this time, Mr. Berry. I would think that if you are a chronic drug user, you would have been involved in the judicial system by now, or at least recently. If taking your answers at face value, and I know Mr. Moody's a very honest lawyer, and he would tell me if he knew of something pending. The court's real concern here is whether you can handle a 13-month-old child, Mr. Berry. That is not the easiest task in the world. I am quite confident that this little one is mobile on its feet by now, gets into everything. You would need to be in a child-proofed environment, be able to change pants, feed, and do everything, whether you have experience or not at that. The court's comfortable that if this initial visitation was taking place with your mother present, I am confident that grandma has plenty of child rearing experience and could be a great source to help you learn to do the same things. So this court will initially order 2 hours of visitation time for the father on Tuesday mornings from 10 a.m. to noon to start. I am a little bit concerned about the logistics, about child exchanges with this distance between the two parents. And Mr. Berry, you're going to need an approved car seat in your vehicle before you can do any transporting. Do you have that? I didn't hear.
Sorry, I was on mute.
Yes, Your Honor.
Okay. Because that's obviously critical to doing any legal and safe transportation of this baby. Is there an effective midpoint between Cedar Vale and Winfield?
I'm not too sure. I don't think so. Maybe we could try Arc City.
Alright, guys, you can really hear the judge trying to keep this case from turning into endless conflict. After granting temporary visitation, the court immediately moves into procedural cleanup, approving late filings, requiring written orders, and separating the DNA testing paperwork from the parenting schedule. That may sound technical, but it's actually critical because clean court orders prevent future arguments and confusion. The judge is clearly trying to keep both sides organized while pushing the case forward quickly instead of letting delays damage the child's developing relationship with the father.